Okay, I'm going to go ahead and get started. Good morning. My name is Amanda Jarvis, and I'm with the Virginia SBDC Network. For those of you that are not familiar with our organization, the Virginia Small Business Development Center is a partnership program between the U.S. Small Business Administration, George Mason University, and local host institutions throughout Virginia. With 27 locations across the Commonwealth, we provide training and technical assistance to small businesses in their local communities. Our one-on-one consulting services are available at no charge. Today's webinar, Protecting Intellectual Property in the Craft Beverage Sector, is the last in a series presented by the Virginia SBDC in collaboration with the U.S. Patent and Trademark Office. You can view these previous sessions at virginiasbdc.org/training. We are recording today's presentation and it will be posted on our website, virginiasbdc.org. Due to the large number of participants, everyone's microphone is muted today. But if you have questions during the presentation, you can type those into the Q&A box. We have also enabled the live transcript function, which you can show or hide via your meeting controls. And now it is my pleasure to turn it over to the panelists for today's session.
Thank you so much, Amanda. Good morning, everyone. Thank you for joining us for this conversation about protecting intellectual property in the craft beverage industry. My name is Chris Van Orden, and I'm the manager of the Craft Beverage Assistance Program here at the Virginia Small Business Development Center at George Mason University. The CBA program is designed to provide industry-specific assistance to Virginia's craft beverage sector. So today's program will be a free-flowing conversation about the strategies that breweries, wineries, cideries, and distilleries can employ to protect their intellectual property. For this session, we want it to be interactive. If you are able to enter any questions that you have in the Q&A function, rather than in the chat, we'll do our best to answer them all either during or after the webinar. So I'm very excited to introduce my speakers today. Elizabeth Doherty is the Eastern Regional Outreach Director at the USPTO. In this role, she ensures that USPTO's initiatives and programs are tailored to the region's unique industries and stakeholders. Welcome, Elizabeth. We also have Jason Lott, who is the Attorney Advisor for Trademarks Customer Outreach at the USPTO, specializing in helping small business owners understand trademarks and the federal trademark registration process. Thank you, Jason. And finally, we have Bill Butcher, who is the founder of Port City Brewing Company. After a successful career in fine wine, Bill founded Port City in 2011 with his wife, Karen. Since then, the company has expanded to 8 states and several international markets and won many national awards for their product's quality. Welcome, Bill. So thank you all for coming today and sharing your expertise, particularly in intellectual property. So I am very grateful for all of you for making the time, and we're gonna kind of dig right in. But before we kind of get into particulars of some of these issues, it'd probably be helpful to define exactly what IP is and isn't, and kind of delineate the different types of protections available. Elizabeth and Jason, would you mind giving us kind of some definitions and kind of groundwork here?
No, certainly. I think we'd be happy to do that. Happy to kick off the program with that basic information. But first and foremost, I want to be sure and thank you, Chris and Amanda, the Virginia SBDC. It's such a pleasure to join with you today with your audience. And of course, Bill Butcher, the head of Port City, which is a neighbor to the U.S. Patent and Trademark Office in Alexandria, Virginia. So we're super excited to be on with you today and to have this, what we anticipate to be a really robust conversation about intellectual property in the craft brewing industry. Intellectual property, and I'm going to invite my colleague Jason to jump in with me, is something as old as the nation itself. Intellectual property protection is actually written into the U.S. Constitution, and as the U.S. Patent and Trademark Office, we began our work in 1790. As our name suggests, the U.S. Patent and Trademark Office is responsible for issuing U.S. patents and federally registering U.S. trademarks. What we generally think of as intellectual property is constituted by patents, trademarks, but also by copyrights that are handled by the U.S. Copyright Office, which is a part of the Library of Congress. And then there's also trade secrets, which I think we may touch on today as well. We love to have these conversations because each and every small business, no matter what their endeavor is doing something that is likely protected by some form of intellectual property, whether it's a patent, trademark, copyright, or trade secret. And companies may be, in fact, creating an intellectual property portfolio. These aspects of intellectual property can bring value to a business by protecting that and having it become a part of the fabric of the business. Jason, don't let me do all the talking. I want to let you jump in here as well.
Sure. So thank you very much. So maybe Liz, you want to talk about like the basics of what a patent is, and then I can talk about the basics of what a trademark is, and then we can maybe touch on copyrights.
For sure, be happy to. So patents protect generally what we think of as inventions, whether it's a new cell phone, whether it's a new toothbrush or a new mousetrap. Patents are issued again, the US patents are issued by the US Patent and Trademark Office, and they protect the invention for, if it's a utility patent, for 20 years from the date of filing, design patents for 15 years from the date of issuance, and they enable an owner of that intellectual property to exclude others from making, using, selling, or importing for sale that device without their permission for that limited period of time. Again, our founding fathers found that it was going to be so critical for the growth of an industrialized nation to protect the rights of inventors and their discoveries. So something, again, we've been doing since 1790, and we've issued over 11 million US patents.
So I'll take the trademark component of that. And really, I think the way to think about trademarks is it's legal protection for your brand. Right? You know, marketers might talk about a brand being like how people feel about your product or how they feel when they experience your thing. And that's great, but how do you protect that, right? And you protect it through what is called a trademark. Most of the time when we think about trademarks, we think about brand names, slogans, and logos. Those are like the big three that we often think about because we use as consumers brand names, slogans, and logos every single day to identify stuff in the marketplace. And that's incredibly key because a trademark is always, always, always tied to very specific goods and services, right? So if I said McDonald's, what do you think of? Hamburgers. Nike, shoes. Ford, trucks, right? So every single time you see or hear that trademark, it automatically makes you think of a particular good or service. And so the same thing is going to be true for you and your craft business. Anytime somebody sees what do they think of? Do they think of you when they see a very particular thing? And if so, then whatever it is that you're using is functioning as a trademark. And that is potentially something that could be protected through federal registration at our office. But I do want to make clear, like brand name slogans and logos, those are like the big ones, but pretty much anything can be a trademark so long as it indicates source. And you oftentimes will see it in, like, think about tequila bottles, for example. You see all kinds of crazy looking different tequila bottles. Well, those different shapes, those configurations of the bottles are actually things that can be protected because when you see a particular shape, you know, oh, I automatically know who that is. So we're going to obviously get into all sorts of other things later on, but I want you to right now already be thinking about what is it that you use to help consumers differentiate your product from your competitors in the marketplace? Is it a brand name? Is it a slogan? Is it a logo? It can be all of those things. It could even be the packaging that you might use. So start thinking right now about how people identify you in the marketplace, because that's really what a trademark is all about. Let me hit copyrights very quickly. And Liz, I don't know if you want to touch on trade secrets really quickly. And then Chris, you can take us wherever you want to take us. With regard to copyrights, what we're really talking about there it's protection for artistic works. All right, so so think about songs, movies, books, paintings, sculptures, the particular design of your logo, for example, that might function as a trademark, but it also might be something that has copyright protection because that is protection for an idea that is then affixed into a tangible medium. All right, remember, there's no like ownership of an idea. There's only protection for when you have expressed that idea and it's been captured in a medium, like you've drawn it or you've recorded it on your phone or you've done a graphic design on your computer, right? So those sorts of things. So patents, trademarks, copyrights, they're all very much interrelated, but they're really protecting different things. So patent protect that invention, trademark protect the brand name for that new invention, and maybe the copyright is going to protect the advertising jingle that you put together in order to help make your product popular.
Exactly, Jason. And again, that goes back to that concept of creating that intellectual property portfolio that you may be availing yourselves of one or multiple forms of intellectual property protection to protect the various aspects of your business. Last but not least, as you mentioned, there is trade secrets. Now, trade secrets are generally protected by the Uniform Trade Secret Act and are often also within an employee-to-employee contract. Trade secrets are anything that can bring value to a business that can be maintained as a secret. Some of those traditional ones that we think of are things like recipes. Who knows the recipe for Coca-Cola or for KFC chicken? Another popular one is the Google search algorithm. How is it they have created an algorithm such that when you put in a few key search words, you get back pertinent and appropriate results? We don't know. Google's been able to keep it as a trade secret. So trade secrets, like trademarks, can have incredible value for a business because they can last forever as long as they can be maintained as a secret and continue to provide financial benefit to a company. But again, it goes back to this larger conversation of creating that IP portfolio. So Chris, I'm going to turn it back over to you and look forward to moving our dialogue along.
Yes, well, thank you so much for that overview. It is very helpful just to set the stage. Just everybody has the sense of the terms, what this landscape looks like. So, even though we talked about sort of four main areas of IP protection for the majority of today's audience, trademarks will be the IP that they'll interact with the most. So I'd love to hear everyone's thoughts on how to start thinking about developing trademarks. Bill, you've obviously had experience with this yourself. You built a brand from scratch.
Yes, we did. And it really, what had started with going back to, we opened the brewery in 2011, but really before that, it was probably 2 years before that was when we started with the research. And really research is where it all begins, starting with ideas. And then the next step is to, catalog all these ideas and then start your research. And when I talk about research, we came up with many different name ideas and worked through them with branding ideas and what we wanted conceptually of what our brand to represent, what we wanted it to evoke, and what the name would symbolize. And so working through these different ideas, through research and looking at whether the name is distinctive. We want to make sure that it's distinctive, that as Jason was saying, that it does evoke something when people see it or read it or say it, that it makes them think of certain things. So having it be distinctive is obviously very important. And also that it's not just descriptive, because that really isn't something that you can protect if it just describes what your goods or services are. So part of the distinction is that it doesn't just describe it, but it also is, it's memorable, would be another way of putting it. And also that it's available, that the name is not currently in use. And that's one of the things that gets more and more difficult as time goes on. When we opened in 2011, there were 40 breweries in Virginia and 2,600 in the United States. And fast forward to 2022, there are over 300 breweries in the state of Virginia and over 9,000 in the United States. So obviously, it's a much more crowded space, and it gets harder and harder to find a name that's available and not being used by someone else. So that's where it's important to do your research, and it's also important to invest in the research. Now, being a startup business, there's a lot of startup expenses that you incur. You're buying equipment, you're hiring people, you're looking at real estate, you're looking at all of these other things to get your business started. And IP isn't always at the top of your list to go and spend money on. You've got all these other priorities that you're working on. However, I truly believe that it's worth it investing in this research to make sure that your name is available. By investing up front, it will save you a lot of time, a lot of effort, and most importantly, a lot of money down the road if you've started on this path where you're using a name that infringes upon someone else. You hate to see someone invest in a brand and in an identity, and then 2 years down the road or 3 years down the road, they discover that someone else had priority to that name, and then they need to look at rebranding. It's something that can be very expensive. It can be confusing for your customers to have to redo all of this hard work you've done and all of this identity that you've tried to build up. And if you're using a name that belongs to someone else, it's just going to cause problems. One other thing that I believe it's important to invest in professional help, get a lawyer involved, because a simple Google search isn't going to do it for you. That might bring up the exact name, but IP lawyers are trained in this, and they can find things that are close to your name that may cause a problem or may not cause a problem, but they can advise you kind of what your chances are of bumping into issues with certain names that you come up with. So that's really where we began. We had to take a lot of names that we liked and throw them out because we found that they were being used by someone else. So there's a lot involved in it. And as I mentioned, it gets harder and harder as more and more businesses enter this space.
Bill, those are excellent points, and I would agree with all of them. And what I would really like to highlight are the two main things that I think will go a long way towards helping folks early on, and that is with regard to distinctiveness. So what you refer to as whether it's descriptive or not, and also this idea of infringement, which we at the office anyway refer to as likelihood of confusion. So we can talk. So those are two reasons why your trademark could be refused registration at our office. Okay, so we can talk about that when we talk about actually taking this step to move towards registering your trademark with us. But those concepts come into play even before you get to the registration phase, because there is in the United States something that's called common law trademark rights. And when you start to use something as a trademark, you're beginning to build your rights in that trademark. You never, ever, ever have to register it with us, okay? You could always, for as long as you wanted to, rely upon your common law trademark rights. And in order to have those rights, you just start using the trademark, right? And that's fine. You can sort of like jump in and do it. But you run into the problems that Bill was talking about, because there is the issue of distinctiveness and also of confusion with other people, right? So that is, what does a trademark do? It indicates the source of particular goods or services. If it's not doing that, it's not a trademark. Right? So if we think about that with regard to distinctiveness, is it actually functioning as a trademark if your trademark is, brewing company? No, not at all, right? That doesn't indicate source at all. It just tells you what you are, right? Think about like generic stuff you used to see, like maybe in the 80s, right? It was a white background with black labeling on it. Beer, right? Spirits. Or like, is that actually functioning as a trademark? No, right? So you have to start thinking about distinctiveness with regard to whether it's descriptive of your underlying goods or services or not. And you want yours to be higher than descriptive. You want it to be suggestive, fanciful, or arbitrary. And I can talk about those in a few minutes. But the other thing is you also want to make sure you're not likely to cause confusion with another business. And that's really a two-step test at its core. It's a bit more complex than that. And the IP lawyers that Bill was talking about will absolutely be able to help you with that. But really what we're talking about is comparing two trademarks and their underlying goods and services, right? So when you're doing that analysis of like, am I going to bump up against somebody else's trademark rights if I use this for my brand? Think about whether the trademarks themselves are confusingly similar in sound, appearance, commercial impression, in their meaning. And in addition, are they being used for related goods and services, right? So you can have two identical trademarks exist in the marketplace so long as the goods and services they're used with are unrelated. For example, think about Dove as a trademark. Dove exists in the marketplace and it coexists, one for soap and the other for chocolate and ice cream bars. And that's totally fine. They can do that. Right. So you need to be doing that analysis very early on to know like, okay, well, this other trademark is out there. It's like pretty similar to mine, but they're doing it for automobile tires. I've got a craft brewery. Probably I'm good to go. Right. Obviously, you want to check that with an IP attorney. But that's the sort of analysis that you're going to want to do very early on when you're in that research phase that Bill was talking about. Make sure you're doing that stuff because those same concepts apply when you say, oh, okay, now I would like to apply to register my trademark with the USPTO. The examining attorney assigned to your case is going to be doing that exact same sort of analysis. So you want to do it first to make sure you don't run into trouble down the line.
Jason, like yourself, I'm really on board with what Bill said. That voice of experience is so incredibly valuable. And Bill, one thing you said really struck home with me because it's something I hear all too often when talking particularly with small business owners, and that's that protecting their intellectual property is a rainy day project. It's something they're going to do and get to when they have more time, more money, or maybe a better understanding of this complex world of intellectual property. And the problem with that, as Bill suggests, is that oftentimes by delaying in protecting your intellectual property, you in fact preclude yourself from protecting your intellectual property. Just start thinking about it from the very forefront, the very start, as you start to create and build and grow your business is so incredibly important. Jason, this might be a good opportunity to take a quick minute to talk about some of the tools that are available for people to actually search their idea for a trademark, and how can they know? Certainly using an intellectual property professional is one great way to do it, but the USPTO also has some tools available to help people discern whether somebody also is already using that fantastic trademark that you're so desperate to have.
Sure. So we have a database of applied for and registered trademarks. And the tool that you use to search our database is called TESS, T-E-S-S, the Trademark Electronic Search System. You will find most of the acronyms on the trademark side of the USPTO have a T in them, and probably an S and probably an E. So it can be very confusing, speaking of likelihood of confusion. But the system that you use is called TESS. It's free. It's available to the public. You can just, pop into it from our website, uspto.gov, and you can search in our database to see if anybody else out there has already applied for or registered a trademark that might be confusingly similar to yours when used with related goods and services. Now, I will tell you right now that the system itself is pretty antiquated. It's like, well, from a technology point of view, it's 20 years old, right? We're working on a new version of it, but we're not there yet. So it's a little bit tricky to use. Some of you, Bill, you might have used it yourself and be like, oh no, never again. I would rather jump into the Potomac than use TESS again. People have that opinion sometimes. So it's not the easiest thing to use, but you can learn how to use it and at least do what we often refer to as a knockout search. And so you just want to look, let's say I'm a new brewery, and I was like, what a cool name would be? Port City. I'm not aware of anybody else using that, so I just pop Port City in the database. Well, guess what? I'm going to see Port City, right? And so we're like, oh, that's going to be a problem. Maybe I shouldn't apply to register that. Let me look up Budweiser. I wonder if that's a registered trademark. Yeah, it is a registered trademark, pal. So you're not going to want to choose that one, right? So you can use our database as a way to do like a quick and dirty sort of search to see what might be out there. Now, if you want to get more complex in our system, you can. There are tools that allow you to do that, to pattern match and use truncation and all sorts of things like that, because you're looking for stuff that's similar, not necessarily identical, but similar, because those are still related. So you can do that as well. But we often recommend working with an experienced trademark attorney, because that attorney is going to know how to do that really in-depth search, that what's referred to as a clearance search. You want to clear the area around your trademark to make sure you're not going to bump up against somebody else. So you can do some of the early work yourself. And if you're like, oh, this is too much, you can also make sure you work with an attorney who's used to doing that sort of thing to help you do that analysis.
If I can jump in, Jason, I think that's a great strategy. And that is something that we employ, because obviously you don't want to invest lots of resources in just an idea. And so doing the knockout search, or we have an arrangement with the small business law firm that we work with, of just doing this 10-minute search for me, a red flag search, and let me know if this is something that I should be concerned about, or is it something that we should take to the next level. And then at that point, we would do a more in-depth search that obviously would cost a bit more, but a lot of times you can just clear those names that pop up immediately, either by using TESS or by having your advisor help you with that.
That's great. Well, thank you all for that kind of look into the due diligence on the front end. Obviously, there's a lot of work to make sure that you're in a good space. So once a company has gone through that initial due diligence and feels confident that the brand that it's trying to get a trademark for is unique and defensible, it's time to register with USPTO. So it would be great to hear a little bit about the application process, both from the sort of receiving end or somebody who's kind of gone through this process themselves.
Bill, you want to start off?
I'd be happy to. And I can vouch for the ease of use of the USPTO website. It is user friendly, even if the technology is a bit old. It's still, once you get used to the environment, it's easy to use. It's not that expensive. And it's what, $300 or something to do
$250 for the cheapest.
Okay. Yeah.
Yeah.
So
it changed since you would have applied. Yeah. We've lowered the price and
Okay.
there's a discounted version available.
Yeah. But that is something that, I apply for our trademarks. I don't have to pay somebody to do that because the website is easy. It goes step by step. You just enter the name there's a field there, and then you go and you can just put the charge on your credit card, and then it goes right through. So it's easy to use. Once you do it the first time, it only takes me about 15-20 minutes to put an application in. So it is something that's easy to use, and it works. Once you have it in there, you get an email confirming that your application is in, and then you don't have to worry because your application is in there, and it's a placeholder and it's a marker that you have applied. And if it goes through, then you're in great shape.
Well, I'll build on that because I just want to make sure that folks know that it's not like just popping in a name and paying for it and then you're good to go. There actually is this examination process that happens, and I know, Bill, you weren't suggesting that was the case, but I want people to be aware that it is it's a little legal proceeding that takes place. Because every single trademark that folks apply to register with our office goes through the same analysis. And it doesn't matter if you're, a small brewery or a gigantic international conglomerate. Doesn't matter. Everybody gets the same level of review. And so your case will be assigned to an examining attorney, and the examining attorney will go through the application and look to make sure, essentially, that you've dotted your I's and crossed your T's, and that from a sort of procedural point of view, that your name is in there correctly, like you've identified yourself correctly, things of that sort, but also the substantive things. Is your trademark merely descriptive? Is it geographically descriptive? Is it likely to cause confusion with somebody else, right? So all those same sorts of things we talked about, the analysis that you were doing before you really got going, that examining attorney is going to be doing that same analysis here. And if your trademark is merely descriptive, it'll be refused. If it's likely to cause confusion, it'll be refused. You'll have an opportunity to argue back and say, whoa, Jason, you don't understand what you're talking about here. This is why it's not descriptive. This is why it's not going to cause confusion, whatever, right? So you can have that conversation with your examining attorney, but you're going to go through the process and hopefully end up with a registration certificate at the end. There is no guarantee, however. Okay, so just be aware. I mean, look, if you applied to register Coca-Cola for soft drinks, just because you applied for it, that doesn't mean you're going to get it. Okay, so that's going to be refused registration because of another Coca-Cola trademark that maybe you've heard of. So there is that process that it goes through. So it's not an automatic sort of thing. But once you get in there, as Bill says, it's great. Like, you've got your application in there. It gives you a filing date. Which is sort of putting people on constructive notice that you have applied for to register your trademark. So that's a really good thing. So the one thing I will say, though, is there is work that you need to do before you actually submit your application. There's a lot of mental sort of stuff that you do. And so, Bill, I'm sure you guys went through this as well, but there are choices that you need to make in your application, which are going to have a profound effect on your ability to register. So oftentimes when people think about their trademark, they think, well, I got my trademark. This is my trademark. I'm just going to put this in there and here's my trademark, right? Maybe-ish, okay? Because you could apply to register various versions of your trademark. Now, for example, Port City, Bill, you've registered it as what's known as a standard character mark, which means that's protection for the wording itself. This is great protection. It's huge. It's broad protection because it means that Bill can use Port City and whatever font style, size, or color he wants to over the life of the trademark registration. Like, that's gigantic, right? You're not locking yourself into your trademark looking in a very particular manner. So you have that choice. You could apply to register that version. But if a logo is really important to you, or there's some stylization that's important, you also have the opportunity to apply to register that version of it, and there's all sorts of variations in between. So you have to make that determination. What's the best way for me to protect my trademark? Do I get this broad scope of protection by just protecting the wording itself? Or is this stylization important? And I also want to submit one for a version that has this. So you're making that determination. You're also making a determination on what are the goods and services that you list in your application. It might be beer, lager, stout, pale ale, right? But maybe you're also using your trademark as a brand name for other things. Maybe you're also using it for a line of clothing that you sell as merch, or for like a line of beer mugs and steins. Maybe you also are using it as you want to register it as the brand name for your retail store services where you're selling your things, or for your tasting room, or for the fact that you are renting out your brewery for wedding receptions and parties and stuff, right? So you have all these different options that you want to think through about whether you want to include that in your application. All right, now the thing to keep in mind with that, and this is why it's so important, is because how you define your goods and your services in your application is going to have an effect, because the examining attorney is going to look for evidence of how you are using your trademark for those things. You're using it as a brewery, cool. Give me that screenshot that shows me Port City Brewery since 2011 or whatever. Okay, cool, great. All right, well, how are you using it as a brand name for your merch? How are you using it as a brand name for your wedding planning and coordination services, or whatever it happens to be, right? So we have to see evidence of how you're doing that, and you submit that. So depending on how you define your goods and services is going to affect what we need to see from you in order for you to actually register. And I also want to say, we can move on to other stuff, but stuff is so important, and I get excited about it. I know that's very nerdy, but it's true. So the other thing to think about is that you are not locked into applying for including all of the goods and services that you use with your trademark in your application. You have a choice, all right? Because remember, you are not required to register your trademark with us. You're not required at all to do that. You could always rely on your common law rights. So that gives you a lot of freedom in your application for what version of your trademark you want to put in there, and also how many of your goods and services you want to include. Because remember, your price for your filing fee is going to be based in a very convoluted way on how you identify your goods and services in your application. If it's just for beer, fine. That's in what's known as an international class. Retail store services, that's another. So that's another $250. A restaurant, a brew pub sort of thing that you have there, that's in a different class, right? You're also doing your wedding planning, that's a different class. Rental facilities, another class. You're like, whoa, Jason, I got $250 that I can afford to put more towards trademark registration. Cool, that's okay. You don't have to include all that stuff. Right? It could just be, you know what? I'm going to take the step like Bill did, and I'm going to register my trademark for my most important product, for my beer, my lager, my stout, my pale ale, whatever it happens to be, right? And so you can choose. And so that way you're limiting, I'm registering my trademark for this very particular set of goods and services. Later on down the line, when I become a successful Port City, maybe I'll submit some additional applications for the other things that I'm doing. But right now, I'm just going to choose this one version of my trademark with these very particular goods or services.
Jason, I love listening to you talk, and I learn something every time you teach on trademarks. Having heard you before, I wonder if it would be beneficial for you to share with our audience today, one, on average, about how long is it taking right now for someone to receive their trademark registration? Two, how long is the trademark good for? What is the duration? Because I know it's very different than a patent. And you've suggested that people have common law rights and don't even need to federally register. So why would they federally register? I think there's a lot of benefits to registering. So it might be worth touching on those. And I'm also going to put in the chat the Trademark Assistance Center, because I want to be sure that people know that help is available through the U.S. Patent and Trademark Office for people who need help either prior to filing, during filing, or after filing.
Cool. I'll try and run through them very quickly because I know there's lots of other topics that we want to talk about, and I could literally talk about trademarks for all day long. So you're going to have to cut me off at some point. All right. You have to take my verbal keys away at some point. Okay. So with regard to how long a trademark registration can last, as Liz mentioned, it is different than a patent and from a copyright. The awesome thing is that a trademark registration can last forever. So as long as you continue to use your trademark in interstate commerce and you file the required post-registration documents with us, which is essentially every 10 years after registration, there's one little outlier between the 5th and 6th years, but essentially every 10 years, it can last forever. So if you want to pass down your business and your trademark to your kids and your grandkids and your great-grandkids, cool, that sort of thing can happen. So how long it takes to go through the registration process? Well, it really depends. We used to say that it would take on average, if you're going to be able to register, 12 to 18 months to go through that process. But then again, it might take years. All right. When I was early on as an examining attorney, I saw a case that had been like in suspension for 10 years or something like that. I mean, so like this stuff can take forever. So there's no guarantee it's going to move quickly. But on average, it was 12 to 18 months. That's been backed up a little bit now because we had this huge increase in application filings during the pandemic. So in like late summer, early fall of 2020, everyone was home, everyone had stimulus money, everyone was like, you know what, now's the time for me to start my brewery or my distillery, right? Or my own Etsy shop, whatever it is, right? So there was this huge increase in people applying to register trademarks. It's created a gigantic backlog. And so our examining attorneys are working quickly to go through it, doing quality examination on every single application, and it just is slowing things down. So it used to be an examining attorney would touch your application for the first time about 2.5 to 3.5 months after you filed. Now that's ballooned all the way up to like 7.5 months, right? So it's a lot longer. So if we think about 12 to 18 months on average, let's increase that by another 5 to 6 months. So maybe you're looking at 1.5 to 2 years, but I can tell you, I've seen trademark applications go through in like get registrations in like 9 months. Okay. So if you now like that's with everything being perfect right off the bat. Okay. So yeah, now maybe you're looking at, a little bit under a year as like a sort of perfect application going all the way through. And then the last thing I will say of why in the world would you even bother with registering if you could just rely on common law rights? Well, because common law rights are geographically located, right? So you're only in your particular area where you're operating and, you've got your distillery or whatever it is, right? Let's say you're not online, you're not on social media, your rights are only in this one very particular place. And because they're state-based, it's only going to be essentially within your state. Well, guess what? As soon as you start selling across state lines and you're expanding out your business, you're going to want to have protection across the country, right? So you get that with federal registration. It creates evidence, or it's called, it creates what's called prima facie, on its face evidence that you are the owner of the trademark and you have the right to use it throughout the United States. It means that you can sue in federal court concerning your trademark. So if Bill gets into it with somebody else that's all the way on the other side of the country, instead of having to go there and sue that guy in state court, no, he can go to the federal courthouse and nearest him and file there and make that other guy come to him. It also means you can use the little R in the circle symbol, which is what everybody wants with regard to trademarks. It also means that you can record your registration with Customs and Border Protection. So if there are counterfeit goods that are coming in, you can have the CBP agents stop those goods coming in. You can also use this as a basis for extending protection into foreign countries. So as you grow and expand and all of a sudden you want to be exporting to Canada and to Mexico and over to Europe and things like that, well, this is going to allow you to apply for registration in those other countries. So there are a ton of great benefits that come from federal registration. And it's in the end, it's probably going to be cheaper for you. So you're not having to go around and just always be enforcing your common law rights. You can just go, hey, judge, check this out. I got a registration certificate right here. And the judge says, OK, good to go. Right. So
that's great. Thank you so much, Jason. I know this is a great area. I would love to talk. Honestly, the international side is of particular interest for me, but I feel like that's its own rabbit hole. So I know there's a lot to cover here. So let's say somebody goes through the process and they do secure that trademark. Congratulations, great news, of course. So now the producer is the proud holder of some IP protections. Things don't end there. So you mentioned the sort of 10-year filings with that little 5 to 6 year additional one involved there. What are some of the other best practices for trademark holders? What are some of the things that they're going to be responsible for? What are some of the things that they should be doing just as somebody who now owns a trademark?
Well, I'll let Bill probably handle this because he knows best. I mean, for Liz and I, like the USPTO is like, we're really pretty narrowly focused on determining whether you have the right to register a trademark not whether you have the right to use it, but whether you have the right to register it. And that's pretty much the extent of what we do. So as long as you're keeping your maintenance filings up to date and things like that, you're okay from the USPTO side. But I'm sure Bill has lots more recommendations on how to protect yourself going forward.
Yeah, Chris, as you mentioned, yeah, that's when the fun begins. You get your registration, you get the email that it's going through. I don't know, do you guys still send out the paper certificates?
For maybe about another month, and then
Okay.
it's going to be electronic. You can still order paper if you want.
Okay, well, it's also cool when that comes in the mail. You've got the gold little star on it that tells you that this is your federal trademark, and that's really when the fun begins. And as someone that's involved in your business, obviously you need to pay attention, and you're paying attention anyway. But the first thing that I did, and we do for all of our trademarks, is set up a Google alert. It doesn't cost anything. You just set it up and they'll send you Port City Google alert. Every time that is mentioned somewhere, it pops up. They'll send me an alert telling me that, making me aware that this has been published somewhere. So that's an easy and free way to monitor and protect your trademark, to make sure that people aren't using it. And also just in your industry, you're paying attention. You're reading industry blogs, you're reading magazines, you're keeping up with what's going on, and you might come across someone that's using your name. But that's how, just being alert and being and paying attention. You do have the responsibility of paying attention to your trademarks and safeguarding them, making sure that they retain their value and that people aren't infringing on your rights.
Bill, I have a question for you. Do you have your attorneys that you work with search through our official Gazette on a regular basis? Is that part of what you contract with them?
No, that's not something that we've done. I just monitor it myself is what I do. And Google Alerts is the easiest way that I do it, but also we're involved in industry competitions. So we see names of other beers that are entered. We go to beer festivals and we see other breweries all over the country. And it's a way just to, we like to stay on top of what's going on. And it's something that every business owner does, of just being involved in your industry. And that's really a great way just to understand what's going on and to stay on top of your trademarks. Because it is something that you as the trademark owner are responsible for protecting.
Yeah, knowing that the onus is on the holder to go through that defense, that's very important. And just making sure that you're using those trademarks. I think Jason mentioned it earlier that, it's not enough to just say, I've got this, it's going to be in my back pocket. You need to say, if you're going to be, going to retain that trademark, putting it into use is a big part. So I think, we all have heard of occasions where, the companies do kind of clash on that front. You look in the news and that happens. Ideally, this being the sort of craft beverage industry is a close-knit community. There are ways to resolve these issues in less formal ways. But honestly, this is an area where an ounce of prevention is worth a pound of cure. Going through, feeling confident that you hold and own that trademark. There are 10,000 other things to keep you up at night as the owner of a craft beverage production business. This doesn't have to be one of them. These things arise and there are ways to address them. So far we've been talking about trademarks here. Obviously, that's not the entirety of intellectual property for this industry. It'd be great to hear a little bit about the patent front. So I know that this is something that maybe won't come up as often within this industry, but it does happen. So it would be great to hear some, opportunities for, securing patents in this industry. And I know Port City is the proud holder of a patent themselves.
Yeah, I'd love to invite Bill to tell our audience about his patent and how they've put the patent to work. It's a remarkable story.
Thank you. We have a patent on our dry hopping device. It's a tank that we use to dry hop our IPAs, our pale ales, any of our hoppy beers. And people are probably familiar with dry hopping, but just in case you're not, it's adding more hops to the beer while it's in the fermentation tank. And the risk that a brewer takes in that process of dry hopping is that you can add oxygen in the process. And oxygen, as all brewers know, is the enemy of fermenting beer. And so we all go to great lengths to prevent oxygen getting into our beer. Well, every time you're moving beer or opening the tank, you have the potential to pick up oxygen. So our original brewmaster, his goal was to find a way that we could dry hop our beers, add more hops without adding any additional oxygen. And he came up with this innovative technique of dry hopping the beer by using this tank that he designed called the hop. We named it the Hopzooka, which also is a federally registered trademark. But anyway, the Hopzooka is a tank that we use to dry hop our beers. And just as we started using this device, it kind of dawned on us that, this is an innovative process, and it could be something that could be protectable. And so, again, we engaged a local patent attorney to come look at it. And it wasn't a big formal thing. I think we gave him some beer the first time we met, and he looked at it and did some initial research on it. He's like, I think you might have something here. And so at that point, we decided to move forward with it and invest in the patent process. And so we applied for it. We got some back and forth between the patent office. And it took a little while. It took a little longer than we expected. But I think it took 3 years or 3.5 years to get our patent issued. But it was on April 5th, 6 years ago. We got our patent issued, and so now we have a distinctive, unique, innovative way of dry hopping our beers. And we actually came up with a little logo for the Hopzooka, and we put that on all of our packaging for all the beers that get treated with the Hopzooka. So I like to liken it to when you buy a computer, it's got Intel inside, and our hoppy beers have the Hopzooka dry hop right on the label. So it's got marketing value for us as well.
Again, Bill, I love that story, and I love that your team really deciphered that really inventive, new, novel way of creating that, infusing the hops into the process. As Bill has said, his team was able to create something that didn't previously exist. And that's really what the U.S. Patent and Trademark Office analyzes when somebody files a patent application. Patent applications come in for a wide range of technologies. We receive over 650,000 applications each and every year and issue approximately 350,000 patents each year. And those patents are for machines, processes, methods of manufacture, compositions of matter. In order to receive a patent, such as Bill and his team did, the invention has to be novel, or it has to be new, not previously known to this world. And when I say not previously known in printed, published, publicly available publications, or what we call prior art. So just as in searching for existing trademarks to know if you can receive a trademark that you think you've come up with, that you think you're the first and foremost, we encourage patent searching, because again, in order to receive a US patent, your invention has to be new. Now, perhaps one of the toughest hurdles, though, is it also has to be non-obvious. Now, what does that mean exactly? It cannot be an obvious variation on an existing device, an existing process, an existing composition of matter, even one that might be created by combining elements. And this is an incredibly tough distinction. It's tough for both our US patent examiners to make that determination. It's also tough for our applicants, because what would be obvious? Is it obvious to take a bicycle having 2 wheels and to take a unicycle that has 1 wheel and to create a 3-wheel bike? Would that be obvious? Well, that's going to be determined by the US patent examiner that examines transportation means having multiple wheels. Your invention also has to have utility or have a useful purpose. In other words, we don't patent perpetual motion machines. that utility bar is a pretty low bar of entry into the system. So it's really that question of, is your invention novel? Is it non-obvious? And again, this is where patent searching, just like trademark searching, comes into play. One's not required by law to do a patent search, but we certainly encourage it. Save yourself some headache, heartache, and financial outlay by looking ahead of time and looking to see if your idea is just so great that somebody's already thought of it. I have to admit, all too often I've heard from people, well, I didn't see my device on the internet. I haven't seen it in the store shelves at Target or Home Depot. It must not be out there. Well, patent searching can be relatively complex. An invention might exist in a trade publication, or it might exist in a senior thesis document that's been published, but it never made it to the commercial marketplace. That could still preclude you from getting a US patent. You know, just like a trademark registration, when your application comes in, it's assigned to one of our over 8,000 trained engineers or scientists to review that application for its compliance with the laws and rules that govern patent practice. They also look at it with their technical competency. Again, they're trained in one of the sciences, and they look at it to see, does it in fact comply with the laws of nature? Does your device work as you say it does? Because also, in order to receive a US patent, you have to describe your invention with such specificity that others can make and use your device. So you've got to fully describe it. That's really the beauty and the benefit of our system. In exchange for you disclosing your invention in your US patent, we are going to entitle you to exclude others from making, using, selling, importing, or offering for sale without your permission. It's a beautiful system, and I congratulate Bill and his team on receiving their US patent and hope that it is just one of many.
Thank you. That's great. Great to know. So all of you out there who are listening today, if you think you're in this space, you have something that is truly unique, take a look. I know it may not be the something that you're thinking about currently, but hopefully we'll get some wheels turning here, and we'll hear, in a few years from now, somebody coming through with a proud owner of a patent here. So I know that we are running short on time, so I won't delve into the sort of international side of the holding your trademarks. It's an area that, if you are considering to grow internationally, getting that trademark is very important. It's a great first step. It may not be secure, and we won't go into first to file versus first use standards and all that for foreign markets. But leaving a couple of minutes for questions on the end, I would just love to ask each of you to share sort of one takeaway that everybody can go home with today, something that you'd like to just impart to all the people listening who would just like to, maybe kind of improve their position on IP. Elizabeth, let's start with you.
Oh, sure. I'm happy to, Chris, and thank you for that invitation. First and foremost, I would say look to the U.S. Patent and Trademark Office as someone who can help you in this endeavor. Whether it's you're a neighbor like Bill, a neighbor to the USPTO headquarters, and you come in person, or you reach out to our Trademark Assistance Center or our Patent or Inventor Assistance Center. The USPTO does not want to be seen as a black box agency. All too often I hear people say, oh, I threw in my patent application, or I threw in my trademark application, and now I'm just going to sit back and hope for the best. We want to be seen as an agency that's known for communication and collaboration. We're in this together with you who are seeking the protection of your rights. We are there to answer your questions. We're there to help you throughout the examination process, because we want what you want. We want to issue you valid US rights that you can take to the bank and not to the courthouse. We want to assist you as you start and build and grow a business. So we have over 13,000 trained and professional staff who love to engage with you. So please don't hesitate to reach out, whether you are thinking about filing, you're in the process, or you've already received your rights and you have a question. We have a number of entrances into the office and a number of resources available to applicants, whether it's our pro bono program where you can get free legal services, or our law school clinic programs where you can get, again, free or reduced cost legal services. whether it's our Patent and Trademark Resource Centers who can help you search for patents or trademarks. We have so many resources available through the U.S. Patent and Trademark Office that we want people to take advantage of them. So visit us on the web at www.uspto.gov or come into our office in person, whether it's the USPTO headquarters or one of our regional offices. Don't hesitate to reach out. We love to engage with you, and we want to help you to protect your intellectual property.
Thank you. Jason, let's go to you and we'll have Bill close us out.
Sure. So here's what I would say. We've already talked about it a little bit, but it's as Bill indicated, doing your research, do it early, do it often. Okay. And because what your takeaway for today would be, don't sell yourself short. Okay. Don't just kind of like skimp out on what you think an okay trademark would kind of be, that sort of thing. Like really do that work to think in advance of how am I going to be able to protect this going forward? And am I going to be able to register it with the USPTO? Because fast forward in your mind, I know, 10, 15, 20, 50, 100 years from now, right? What is going to give you the best chance of success? Is it a trademark that is like pretty descriptive or geographically descriptive? Or is it going to be a trademark that is fanciful or arbitrary or suggestive? Those types of trademarks may early on be harder for the consuming public to be like, I don't know who that is. So it takes some time to educate them that when they see your trademark, they automatically know, that's a tasty beverage, right? So it's going to take a little time perhaps to do that education, but in the long run, it's going to help you more because choosing a trademark that is kind of weak or just barely different than somebody else's is going to be way harder for you to protect, and it might be difficult for you to register it at our office. So it's put your creativity like on full throttle. All right. So start thinking about these things, because if you think about the top brands around the world, those are mostly fanciful, pieces of wording or arbitrary. I mean, think about Kodak or Kleenex or something like those are just made up words, right? They don't mean anything, but they have incredible value because trademarks can have immense value. Apple has their brands have been valued in the hundreds of billions of dollars, right? Same thing with Microsoft and Amazon and things like that. These are $50 to $100 billion just on the trademark alone, right? Doesn't have anything to do with any of their physical plant, any of their actual products or anything like that. It is just the value of their trademark alone. So I want you to think of yourselves that way too, and think about how valuable your trademark can be.
Cool.
Thank you, Jason. Bill.
Yeah, I mean, the research aspect of I think we've done a pretty good job of hammering that home. That's for sure. So one thing about defending your trademark that I did want to touch on is that, our industry, craft beverages, we're known as kind of a collegial industry, and defending your trademark doesn't mean immediately sending a cease and desist letter if you see someone using your name. Our approach has been, over our 11-year history, has been a more collegial approach. For me, if I see someone using our name, it's a phone call. Say, hey, unfortunately, I think you're going to have a problem with this name. You may have missed that we have this federal registration for this trademark. So you really ought to take a look at that because it's going to give you problems down the road. So we try to take a more collegial approach. It doesn't have to be confrontational and really go into a judge or a cease and desist. That's more down the road and kind of a last resort for us. But it is important to raise the issue, to make sure that people know that you're out there if it comes up. And the piece that I would leave with everybody is that, after you've done your homework and you've invested in professional help where appropriate, then be diligent and do protect your trademark. And kind of like Jason was saying, treat your intellectual property like it is a valuable asset because you want it to be. Even if it's not now, the goal is to build it up to have value. So be on the lookout and protect your assets. If you find that your name or your idea isn't working, you also need to always love your plan B.
That's great. Thank you, Bill. And I think we will leave it at that. So thank you all for joining us for today's discussion of IP. Each month, we host a session in our Craft Beverage Conversation series. So next month on the 25th, we'll be discussing the role and responsibilities of the TTB. But for now, I would really like to thank today's speakers for sharing their expertise and insights. Really appreciate you making time to share this with our audience. Thank you very much. And I will turn it over to Amanda.
Yeah, thank you so much. Thank you to the panel for the awesome discussion today. Thank you everybody for attending and for your questions. I just wanted to let everybody know you're all going to receive an email with a link to the recording from today. If you'd like to sign up for upcoming webinars or access recorded webinars, please visit virginiaspdc.org/training. All of our resources are designed to be used in collaboration with your local SBDC advisors. So you can sign up for a free and confidential session by emailing help@virginiaspdc.org or via our website. And I also put those in the chat. Thank you again for attending, and we hope to see you at the next session.
Thanks, everyone.
Thank you.